Welcome. Today we're going to discuss an opinion made by the Trademark Trial and Appeal Board in the case of In Re Medline Industreis. My name is Scott.Slavick. I am the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, or searching and clearing new global brands on a rush timeline, or reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In this case, Medline's application to register a green exam glove was rejected by the USPTO, so Medline appealed the rejection to the Trademark Trial and Appeal Board. To provide some background for this case, the USPTO maintains both a principal and supplemental register for trademarks. The difference between these registers is the strength of a mark. While trademarks on the principal register are required to be inherently distinctive or have acquired a sufficient secondary meaning, the only requirement for marks on the supplemental register is that they are capable of distinguishing goods or services, not that they actually do. Marks will often be registered on the supplemental register because they are not yet eligible for the principal register, but may be one day. In cases where marks are being applied for on the supplemental register, the standard for receiving a mark is much lower. In 2019, Medline Industreis, a leading manufacturer of medical gloves, submitted a request to register the color of their green medical gloves, Pantone 2274C, on the supplemental register. The trademark examining attorney rejected their application based on its likelihood of confusion with another mark. After its examination, the trademark examining attorney did not find sufficient distinction between Medline's desired trademark for green medical gloves in the shade of Pantone 2274C and an existing mark for green medical gloves in the shade of Pantone 7488U. On the left is a mock-up image of the medical glove Medline Industreis tried to register to the supplemental register. On the right is the medical glove that Avent Inc. had already registered. Because of the similarities in both the field, medical, and color, green, of the gloves, the trademark examining attorney did not find the two designs distinct enough to grant Medline Industreis a mark. Medline Industreis disagreed with this assessment and appealed the decision to the Trademark Trial and Appeal Board. The examining attorney for the USPTO maintained that both Medline and Avent's marks could be described in ordinary language as the color green. Because Avent already had registered a mark for green medical gloves, it argued the USPTO could not allow Medline to also register green medical gloves, as that would cause confusion within the market. To bolster this argument, the examining attorney cited a precedential decision from the Trademark Trial and Appeal Board involving the issue of likelihood of confusion between two single color marks. In that decision, In Re Cook Med Tex, the Trademark Trial and Appeal Board rejected Cook Medical's application for a mark of teal medical devices as a registered mark for blue catheters already existed. This decision, the examining attorney argued, set clear precedent to reject Medline's application for green medical gloves on the basis that Avent already had a trademark for green medical gloves. Medline Industreis argued their case on the basis that their application for color was not similar enough to Avent's color to cause confusion. Medline contended that while certain shades of green may be sufficiently similar to cause confusion, Pantone 2274C and Pantone 7488 were not. Medline pointed out that the color they hoped to mark, Pantone 2274C, is a light pale green, while Avent's mark for 7488U was significantly darker and brighter. As such, consumers were unlikely to be confused between the two different brands. Although it is rarely straightforward to distill any legal decision down to just a few factors, the crucial elements of the Trademark Trial and Appeal Board's decision on the matter included the strength and similarity of the requested mark. The Trademark Trial and Appeal Board ultimately decided in favor of the applicant, but it wasn't a cut and dry decision, with factors weighing in favor of a likelihood of confusion. The first issue that the Appeal Board chose to address was the strength of the mark. This was relatively straightforward for the board, as they cited Cook Medical's precedential decision and sided with the examining attorney that green medical gloves were very common within the market that they lacked strength. The second issue that the appeal board chose to address was the similarity of the marks. Despite siding with the examining attorney on the strength of the mark, the issue of similarity played out differently. To establish similarity between marks should be compared in their entirety, from appearance to commercial impression. On the matter of commercial impression, the TTAB swung heavily in favor of Medline Industreis, evaluating the matter from the perspective of both purchasers of bulk medical supplies and the end users of the goods. Despite being green medical gloves, the TTAB found that consumers who had used or seen different kinds of green medical gloves were not likely to view the two shades as similar, or to view gloves bearing them as being the product of one and the same producer. For those reasons, they found that the claimed marks were distinct and therefore similar. Additionally, the board did not find the two gloves to be confusingly similar in appearance. Although the examining attorney argued that the gloves were too similar because they were both green, the board disagreed. Because the drawings in the application and cited registration were in color and showed the particular shades of green claimed, and because both referred to Pantone designations to identify a specific shade of green, the board concluded that it cannot simply read one color claim to encompass the other color claimed. As such, they leaned in favor of finding no likelihood of confusion. The board ultimately concluded that the issue of similarity outweighed that of strength and reversed the USPTO's refusal to register Medline Industreis mark. Whether and to what extent a color can be protected under the trademark laws has long been a vexing issue, both in courts and in the Trademark Trial and Appeal Board. That is why this is an important case. This is the first precedential likelihood of confusion ex parte reversal since 2015. It is also only the second precedential decision on single color marks that the TTAB has issued in the last 25 years since the Supreme Court's landmark color decision, Qualitex versus Jacobson. In Qualitex, the board held that a single color can be protected and registered as a trademark. In this case, the board agreed with Medline that the scope of Avent's prior registration cannot extend to all shades of green gloves, as a single entity cannot properly claim exclusive rights to the entire spectrum of greens. Since Qualitex, the lower courts have recognized that multiple companies can use different shades of a color for the same product without confusion. In essence, if the examining attorney's position was adopted here, it could have effectively created a monopoly on a significant portion of the color spectrum, giving the prior registrant the exclusive right to use all shades of green and to stop competitors from using any shade of green, whether confusingly similar or not. It's also important to remember that just because the Trademark Trial and Appeal Board approved Medline's application, if Avent really felt that the marks were confusingly similar, it could always oppose Medline's application. It will be interesting to see if cases continue to follow this idea that multiple shades of the same color can peacefully coexist, or whether applicants or litigants will be able to push farther to try to protect multiple shades of the same color. The decision does, however, clearly provide hope for applicants using color marks that those marks may be registerable regardless of the pre-existing color marks, and that alone is not a significant implication of the court's holding. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.